Okay, welcome to Chapter 9, Punishment and Sentencing. We are going to really begin a transition with this chapter between what we've been talking about in the court system, the trial, the determination of guilt, and we're going to move over towards the correction system where people wind up after a conviction. So this is very much a bridge chapter between these two extremes. The extreme of not guilty, you go free after the trial, and guilty, now you're going to wind up in the correction system. And I think it's fair to start this chapter with asking you, to reflect on the whole idea of how this chapter is entitled, Punishment and Sentencing. It is incumbent upon a student to examine the fundamental ideas behind what people are talking about. As a student, that's one of the best things we can do. And as a teacher, I can lead you there, and I can say these are things that you need to examine, but you have to make up your own mind about much of this. So when I talk about punishment here, one of the things I want you to think about is why punishment? Why are we interested in the idea that if we find someone who committed a crime that they need to be punished? This is a very old idea. This is an intrinsically human idea. There's nothing wrong with it. But it's fair to ask that question, and it's fair to examine where asking that question takes us. So that's, one of the things I like as kind of a background to this chapter to talk about. Okay, let me move on. Now I will be moving away from the slides in one place here, and when we get there I'll show you what it is. Okay. Your book has a listing here of 4 purposes behind sentencing. And again, as I've said in other lectures, anytime someone gives you a list and says there are 6 reasons for this, or there are 7 parts of that, you can ask fairly, well, are there just 4 parts or purposes to sentencing? Aren't there 5? Aren't there 10? Who decided there's just 4? I mean, obviously in this case it's going to be the authors of your book, but the question becomes, are there more? Are there things that are being left out? Is there a step before this? And that goes back to that question I just posed. Why punishment? Okay, so punishment really is very closely linked to this first term, retribution. And this is a very old term. It's both a Western and an Eastern term. It's a biblical concept. Many of you, I'm sure, have heard of the expression, an eye for an eye, a tooth for a tooth. When someone commits an act, someone takes someone's eye, they should lose their own eye. And it is punishment. So retribution is the idea that people get a just desert. They do something and they are punished for it. Now, the proportionality there is something that was fought about. It's really not until the 1700s that proportionality really becomes an important component. So some things that you might think, well, that seems a relatively minor crime, I wouldn't punish people for. In the old days, there were very horrific punishments for. Conversely, there are things today we punish people for because we deem them to be very wrong, for example, beating your wife, that in the past there was no retribution for because they weren't viewed as crimes. So retribution carries a moral weight as well. It says that we find something morally distasteful about this, and the more punishment, the higher the proportionality, the worse we tend to find it. So we say, for example, the worst crime you can commit is taking someone's life. The second one is deterrence, and I would really break this up into 2 specific and general deterrence. This is really using the correctional system, the punishment idea, the sentencing idea to manipulate the future. You're going to say, we're going to prevent crime either through general deterrence or specific deterrence, and we'll examine those in a little bit more detail. But quickly, general deterrence is the idea that you are punishing someone to provide an example to everyone, to the general public, if you will. and that by in the old days in the Old West, you hung a horse thief not just because he stole the horse, but so that other people wouldn't steal horses. Specific deterrence is you are trying to deter a specific criminal in the future. So I've taught courses on serial killers, and it's fairly well demonstrated that serial killers don't stop. So the only deterrence you have for a serial killer is the very specific act of killing him. Incapacitation. Incapacitation is something that we do quite a bit of in America, and this is preventing crime by detaining wrongdoers in prisons, separating them from the community, removing them from society. And this goes back quite a bit. This also reinforces the idea, which makes many of us feel very comfortable, that criminals aren't us. They are the other. They are the one outside of the community, and by removing them from the community, we make the community better. Again, nothing wrong with that idea. Rehabilitation, again, this kind of deals with the future, much like deterrence in some ways. Rehabilitation is the idea that you're going to fix people. This is a seductive idea. This was an idea that was extremely popular for a while, then it kind of waned and might be coming back a little bit. But this is the idea that people, when they mess up, can be put in situations where they won't mess up again, where they'll be rehabilitated. So a classic example would be if you catch someone who is a drug user and you arrest him for possession of marijuana or cocaine or heroin or something, you rehabilitate him by helping him break his habit. And as for how successful that is, well, you have to ask yourself the question. We make a lot of DWI arrests in North Carolina and across the world every day. And how successful are we at rehabilitating alcoholics? Are we good at externally, through punishment or through removal, good at getting people stopping drinking? I think that's a legitimate question to ask. Okay, now the rise of structured sentencing, and we're getting close to where I'm going to break from the slides in a second. But legislatures make laws and determine the types and the lengths of sentencing. Now in North Carolina, which I'm about to show you in a second, the North Carolina General Legislature classifies its felonies as an A felony, a B1, B2, C, D, E, F, basically through the alphabet, although obviously not to the end. We also call our misdemeanors an A1 misdemeanor, a 1 misdemeanor, or 2 misdemeanor. So the A felony in North Carolina is first-degree murder. And then down from there, B1, B2, C, you're going to get the more serious crimes like rape. And then by the time you're getting down to C, D, E, F, G, you're getting into things like burglary. So the legislature determines in indeterminate sentencing what is the maximum and minimum time to be served. And it leaves it up to the judge. And that's indeterminate sentencing. Okay, this guy could get 5 years, he could get 2 years. And when I first started practicing in North Carolina, this was very much the model we used. I would have clients sometimes convicted of crimes, and they would get a sentence of 2 or 3 years, or potentially a sentence of 2 or 3 years, and they might only serve a year. Determinate sentencing says, we're going to take that power away from the judge. We don't trust the judge as much as we used to. We want sentences to be standardized. And this has both good and bad ideas behind it and purposes behind it. One of the things you could seek to do by doing a determinate sentencing structure is to remove racial bias. You say, okay, well, if African Americans or Hispanics were getting very long sentences for the same crime, let's get rid of the authority of the judge to change the sentence. Let's just give everybody 5 years. And that would be a determinate sentence. And we did that a little bit, although it did not necessarily get rid of things. Okay, good time is an unfortunate, perhaps, necessity inside most correctional systems. When you put people in prison, you have to have a mechanism to control them. They're already in prison being punished by being there. You're depriving them of their liberties. How do you get them to behave? How do you get them to be not aggressive? How do you get them to follow rules? How do you make your corrections officers safe? And the answer to that is good time. You tell them, look, if you behave in prison, you'll get out earlier. If you misbehave in prison, you will stay in prison longer. Legislatures have also, by passing in many states, have something very similar. North Carolina, and I'll show you the chart in a minute, has something where we say you've got to serve a fair amount of your term. 85% is a common number. Now this is where we're going to depart here. Okay, so if we look at, let's hope it comes up, and there it is. If we look at this, this is the North Carolina structured sentencing chart. I hope you all can see this, and I apologize for it, but this is the best way I can put it in there. You'll notice that this is Class A. That's life imprisonment with parole or without parole or death. So that's going to be pretty much exclusively for first-degree murder. And if you look down from there, I mentioned we have B1, B2, C, D, E, F, G, H, I. Those are all of the different felonies. So you might have a very, very minor felony would be a Class I felony. A very serious felony might be a Class C. So what we do in North Carolina is this, and I'm jumping ahead a little bit. First of all, we have in statute what your felony is, A, B1, C, D, E, F. So let's suppose it's a D felony. Let's suppose you committed a crime like burglary or arson or something, and the state legislature said it was a D. Okay, so now you come in my office and you say, okay, I was accused of this crime, and I say, okay, that's a D felony. I know I'm in this block right here. If you'll see this block, okay? So the next thing I do, if you'll see up here, we have these Roman numerals, 1, 2, 3, 4, 5, 6. That is your prior record level. We give you points in North Carolina for basically past crimes in most cases. So if you have no past crimes, you have and no other reason to give you any points, you didn't commit this while on probation or parole or something, because that gets you points as well, you would have 0 points. So if it was a D at 0 points, you'd be in this block here. Okay, this block says 64 to 80, 51 to 64, 68 to 51. But let's suppose you were a bit of a bad boy. Let's suppose you had committed several past crimes, and in fact you were at a level 3. So you would be in this block. 84 to 105, 67 to 84, 51 to 67. This is your sentence. Now if you see a little A here, you can see the A, that means active time. That means you are going to jail. You are going to go to prison, excuse me, not jail. You're going to go to prison. You're not getting community sentence, you're not getting a probation, you're going to go to prison. What is the length of your sentence? Well, all these numbers are in months. So assuming you had the most mild possible sentence, so you cooperated with the police, you informed on other people, you didn't hurt anybody, you were a means of support, you have good rehabilitation, so we're going to put you in the mitigated range. You will get a sentence of 51 to 67 months. So what that comes out, you'll get either 4 years and a little bit or 5.5 years in prison. But let's suppose you were a bad boy. Let's suppose you committed a terrible crime and you were aggressive and it was part of a criminal enterprise and you did it for profit, and we just said, well, you're the aggravated level. There you would get between 84 and 105 months. So you can see the difference here. We're going to go from a little bit more than 4 years to over 6 years as your minimum sentence, and you're going to go, a little bit more than 5.5 years to, creeping up to 8 years. And that's the difference between the two. Now, if you see an A, that's your active time. That means you have to have an active sentence in prison. If you see where you see these I's, these are intermediate. That means that it's going to be up to the judge. He does have discretion there, how much is going to be active time, how much is not. But you notice that that's only starts at E, which is starting to be the less serious felonies. By the time you get down to the least serious felonies, you will see, with no prior record level, it is possible to get a C. And a C is community service. It means no time in prison. And you'll notice that the shortest period of time you can be sentenced to is 3 months. Okay, let me get back to our slides here. Okay, so throughout the pretrial process, the judge is pretty passive. Within this legislative control that's been put on the judges, they have some discretion. Capital punishment, imprisonment, probation, fines, other forms of punishment. Those are the most common ones. Now, capital punishment has special rules. Imprisonment, again, you just saw that chart. Sometimes the judge has no choice. He might say, well, I'm not sure you're that bad a person and you really need to go to prison, but the general legislature said that's it, so you're going to prison, my lad. Probation, fines, and other punishment, all things you can understand. Okay, so the major participants in the sentencing ritual, as your book calls it, is the judge and the probation officer. Now, the book also lists, that the defendant, he doesn't really have a lot of pull anymore. It's really the judge and what's recommended to him by the probation officer. He's going to create what's called a pre-sentence investigation report. Assuming this is a serious crime, the judge is going to get a pre-sentence investigation report that says, okay, here is the likelihood this guy gets out and can stay on the straight and narrow. Here's the likelihood that this guy is going to pull his life together or has the resources to do it. And this is really going to help the judge determine how much he feels is appropriate. It also helps him determine, because the prosecution and the defense are going to make arguments that this is if we go back to that slide, if you recall before, I won't bring it up, that this is an aggravated or mitigated sentence. So if it is a capital case, if you face a death penalty, and realistically in North Carolina that's only going to be a first-degree murder case. If it is a capital case, the jury actually makes the decision. We have what's called a bifurcated trial, and in the bifurcated trial, the jury decides, one, the first part of it, because it's a split trial, did the individual commit the homicide, and two, the second part, after they decide that, does it warrant death? Judges can give instructions, but the jury makes that decision. For pretty much everything else, the judge gives the jury instructions on the ranges of penalties available if and when someone comes back on the rest of it. All right, so what are the factors that go into sentencing? Well, one is, how serious is the crime? The legislature is going to define some crimes as very serious: murder, rape, assault with a deadly weapon inflicting serious injury, all very serious crimes. And they're going to say other crimes, well, they're not so significant. So if we move out of felonies for a second, general legislature might say, simple assault, you slap somebody. Yeah, that's a crime. You don't have the right to hit people. But we're not going to send you to prison for 20 years. The other factors that go into sentencing, and these are the aggravating and the mitigating circumstances. And North Carolina has a list. If you take our correctional law class, we'll go over some of that list. But North Carolina has a list of what factors are aggravating, what factors make your crime worse. Those could be things like, did you harm the defendant? If you kidnapped them, did you rape them? If you harmed them, was it a permanent injury? Did you just beat them? Or did you beat them so badly they lost an eye? Mitigating circumstances are things that can lead to lighter sentences. Now, sometimes they're actually built right into the statute. So, for example, in North Carolina, one of the things that distinguishes first-degree kidnapping from second-degree kidnapping is first-degree kidnapping, which is punishable by a harsher sentence, says you harm the individual. But second-degree kidnapping says you didn't harm them and you release them in a safe location. So it gives the perpetrator an incentive. Well, I've already committed kidnapping. I'm likely to get caught. I'm not going to kill this person, so I want to minimize this. I'm going to let them go in a safe place. Also, a judge's personal sentencing philosophy can definitely impact things. I've been in front of judges. Some judges are very much lock them up and throw away the key. Let's be very harsh. And some judges are more compassionate. And they can be compassionate for people that they feel compassion towards, and they can be harsh against people they don't. And that can be, and it's fairly well demonstrated, a matter of race. It can be a matter of age. It can be a matter of social economic status. It can be a matter of religion. A lot of things go into it that are not necessarily on the black and white in front of the page. Okay, so we do have some inconsistencies in sentencing. We have sentencing disparity and sentencing discrimination. So sentencing disparity is two people get convicted of the same crime. So Bob commits burglary, Fred commits burglary. Bob gets 10 years, Fred gets 1 year. The question is, why? There could be good reasons for that, but why? Sometimes a sentence is influenced by external variables. Now, one of the ones that we don't tend to think about as much and doesn't really bring down as much condemnation in our society is gender. There is a well-demonstrated bias in favor of women in sentencing. So it goes by different names. I've seen it called the chivalry effect or the Galahad effect, but basically you can see a woman commit the same crime that a man commits, and they will tend to get a lighter sentence. You might argue, well, that's because most of the time if women are committing the crime, they're not the chief architect of the crime. So often you'll see a man and a woman convicted of distribution of narcotics, and the man will get a harsher sentence, and people will say, well, the reason for that is the man was behind it all. He coerced the woman, or she was his wife. Which is a bit sexist to take that approach, but it may have a gram of truth in it. Race and economic standing, those are a little bit darker. Those are a little bit more questionable and go to the heart of prejudice. They clearly can affect sentencing. A person's race, religion in the past more so, not as much now. Economic standing, definitely. There's not a lot of rich people that wind up in prison. Okay, so offenders can receive under disparity similar sentences for different crimes of unequal seriousness. So you can have someone that gets 5 years for jaywalking and someone that gets 5 years for assault with a deadly weapon. That would be a disparity sentence. You can get different sentences for unequal crimes. Okay, this tends not to be as bad. Or mitigating and aggravating circumstances can have disproportionate effects. So you can say, well, we're going to value this thing very highly and not value that. And that can create a disparity. And sometimes that's intentional, and sometimes it's both logical and moral and ethical to do so. Sometimes, unfortunately, not. If we look at the punishment penalty, the rates of imprisonment rise sharply for young, for the minority, and for the unemployed. And you might as well add into that race. So if you are, and gender, if you are a young black or Hispanic male and you are unemployed or poor, you will see higher rates of imprisonment. We also, and this is the chivalry effect or the Galahad effect, women convicted of crimes are less likely to go to prison than male counterparts. Again, I think I've told you this. I've taught classes on serial killers, and there have been cases of serial killers, men and women operating together, where they get caught after killing people. And there's been at least a couple of cases I'm aware of where the man is executed or receives extremely long sentences, and the woman serves a much shorter sentence and is let off. And sometimes there's not a lot of evidence to show that they behaved remarkably differently or were less cruel or less motivated behind this. Okay. Judicial discretion has pros and cons. One of the questions we can ask is it good to give judges that authority? Who is a better judge of what goes on? The judge sitting in the courtroom, who sees the participants, or is it really the legislature who can look at something from afar neutrally and say, this is the standard we should go for? So I would say the critics of judicial discretion really have been on a roll. Since the 1980s, more and more states have adopted structured sentencing. When I first started practicing in 1986, pretty much the only crimes that had structured sentencing in North Carolina were drunk driving. And there were different reasons for that, primarily because I think the system had been pretty badly abused by drunk drivers getting off for charges. But what happened within a few years was Congress in 1984 had passed the Sentencing Reform Act, and gradually judges lost a lot of their power. That didn't mean the power disappeared. It went to the legislature to set the penalties, but where it really went, if you think about this, is it went to the prosecution. Because now it was less important what the judge thought the penalty should be than the charge that the prosecution decided to pursue. So laws have been passed by politicians that limit judges' powers. We have habitual offender laws. We have these in North Carolina. We have 3 strikes you're out laws, or something very similar. They're pretty unpopular with judges, and they clearly have a racially discriminatory effect, because don't forget that discrimination can be systemic. It can be built into a system, even though it appears to be neutral on its face. We can, if we want to reform this, maybe we go repeal it. Maybe we limit the habitual offending triggers. Maybe we give judges more discretion. And these are all things that are being examined. And here's one of the things where you have to think about, what kind of system do I want? Do I want a system that an individual man makes the decision? Or should there just be the law behind it and just have him kind of as a conduit for what the legislature is? All right, the victim impact statement is something relatively new in the law. Although victims have always been able to testify at conviction, one of the things that we've really seen a rise of, particularly in death penalty cases, is the victim impact statement, which says, let individuals who were harmed by, in this case, a homicide, so it would be a husband of the deceased wife, come forward and tell how the homicide affected them. Not did Fred kill her, not the evidence that Fred did it, but rather the impact it had. So one of the things I've seen, there's some videotape out of Florida about a series of killings that occurred in Gainesville. And one of the things that happened was the victims' families were able to come forward and testify and talk to the judge about how this whole thing impacted them, how it had such a dramatic impact upon them. And I think it really hits home when you see things like that, where someone says, well, this was my only brother, this was my only child, and my name died with them when this individual killed them. And that victim impact statement really gives the victim a voice, which had been lacking in the system. So it gives survivors a voice. It can be very therapeutic. It can help the judge and the jury appreciate. The cons here is it can really bring a lot of emotion into the courtroom, and we're already very emotional animals. And emotion can, not always, but can lead to bad decisions. So we have to be somewhat hesitant to bring in emotion, and as we bring it in, we have to really be careful it doesn't excite our prejudices. All right, I said I was going to talk about capital punishment, so let's go forward here. The death penalty, or capital punishment, is in theory available in North Carolina for a number of crimes. There is a statute, for example, if you were to take a life by using a weapon of mass destruction, so if you set up an A-bomb in downtown Raleigh, yeah, you would face the death penalty. But realistically, in 99.9% of all cases, what we're talking about here is someone that commits what would be called in North Carolina first-degree murder. So what are your methods of execution? Well, here are a listing of the 5 methods that are traditionally used in the United States. Electrocution, more popular in the past than it was today. Lethal gas, don't see it too much. Hanging, again, fairly rare. Firing squad, you might think that's a military punishment. In fact, at least I know of one state, Utah, that has firing squad because of a connection to Mormonism. Not to say Mormons promote firing squads, but there is an idea in Mormonism, as I understand it, that you can atone for taking a life by shedding your blood literally. The most common and the dominant one is this last one, however, lethal injection. That's how most individuals are executed, wind up being executed in the United States. Okay. In the 20th century, starting around 1910, we began to see a number of cases, and we began to question the constitutionality of the death penalty. So in Weems versus the United States in 1910, the Supreme Court clarified to some extent the meaning of the words cruel and unusual. And then there's a series of cases, Furman v. Georgia and then Gregg v. Georgia, that really questioned and then reestablished the death penalty. Now, what, as late as 2008, the Supreme Court said the mere possibility of pain does not establish the sort of objectively intolerable risk of harm that qualifies as cruel and unusual. So there's a lot of challenges right now about what methodology we can use. Lethal injection has run into some problems, and I'll just do a kind of a detour here. As I understand it, the primary drugs that are used for execution are not manufactured in the United States. They have to be obtained from overseas, and the primary producers of these was Italy, or are Italy, and the Danes, Denmark. And since neither of those countries have the death penalty, they will not export them to the United States for the death penalty, and that's really made it difficult for us to use lethal injection. Okay. I mentioned this case a minute ago, Furman v. Georgia, and this was really what many scholars thought in 1972 was going to be the beginning and the end of the death penalty. In 1972, kind of towards the end, the last gasp of the liberal courts of the 1960s and 70s, the Supreme Court of the United States said, we're going to put a moratorium on the death penalty because as it's being administered, now they didn't go to the idea that fundamentally the death penalty was wrong, but they said the way it was being administered was wrong. So they said, we're going to give you an opportunity to create a system that's fairer. But until then, nobody gets executed, and that was Furman v. Georgia. And the solution here was what was called a bifurcated case. And this comes out of Gregg v. Georgia, a later case, only a few years later. And you have a two-stage trial. The first stage of the trial, the jury determines guilt. And in the second stage, the jury then determines should he be executed. And if they can't agree to the death penalty, then the presumptive sentence is life in prison. So this is a breakdown. You can see it here. Stage one, if you're not guilty, that's it. You let go. If you're found guilty, then we have kind of a second trial, the purpose of which is not to establish did you do it, the purpose of which is to establish should we execute you. And again, we leave that up to the jury. The juries are deeply involved in this. Now, there's only one state, and that's Alabama, where a judge has the power to overrule the jury and impose the death penalty. It's rare, but I have seen it, and I have read of cases where it's done. Now, there are certain circumstances that Supreme Court have said you cannot execute people for, and these are absolute mitigating circumstances. One is insanity. In 1986, we decided if someone was irrevocably insane, you can't execute them. In 2002, we set a standard of mental retardation, and in 2005, we set some age limits. Prior to the 1980s, you could have people with exceedingly low IQs, very young age, be executed. If we had time, we could go into the Stinney case, which is a South Carolina case, and I recommend you look up that case if you're so interested, about how we executed basically a 14-year-old boy. It was in the South during segregation, Jim Crow. He was accused of killing 2 white girls, and his family was run off. He was given very poor representation, and his trial lasted all of a day. There was supposedly a confession, no records of it, and he was executed. So gradually by 2005 we put some limits on this. You had to be an adult. We also put limits on what your level of intelligence or mental retardation can be. So there are some debates surrounding the death penalty. One, is it a deterrence? Now remember, there's 2 types of deterrence. There's general deterrence and specific deterrence. There's not a lot of good evidence, to be fair, that it functions at all as a general deterrent. Societies that have the death penalty do not have lower homicide rates. Even inside the United States, sometimes states right next door to each other that have the death penalty do not have lower homicide rates. It is perfect specific deterrence. That person will never commit another crime, but it's probably really not a very strong argument for deterrence. The next one is a bit of a problem. That's fallibility. Unless you believe that the government is perfect, unless you believe that the government never makes a mistake, then you're going to have to admit the probability that at some point we will or have, and I think you can demonstrate with some accuracy we already have, executed an innocent person. And is that okay? Can you have a action which is not necessary, because you have life without parole as the alternative, but you want it so badly that you're willing to execute innocent people? Arbitrary, or arbitrariness. There doesn't seem to be a lot of pattern to who gets the death penalty and who doesn't. You might say, well, it's only the worst of the worst. No, there's not a lot of evidence for that. In fact, some people commit very horrific crimes. Jeffrey Dahmer, who was a serial killing cannibal, didn't get the death penalty. And then other people commit crimes. George Stinney, who probably didn't do it. I would say didn't do it. I wouldn't say probable. Who does get death penalty. And that brings up the last one. It's discriminatory. Who gets it? And again, young, poor, minority males. Okay, if we look at a breakdown of the states here, you'll notice that North Carolina there, if you can see my little arrow, North Carolina, we have 43 executions between 76 when it was reestablished in Gregg v. Georgia in 2015. By far the winner, Texas, no surprise there. Texas has executed 531. Nobody's close. Although for sheer population, you'll notice that Oklahoma, right above it, has 112. It's number 2, and trust me, it does not have that large a population. Oklahoma, I'm sad to say, has one of the worst criminal justice systems in the United States in regards to representation and penalty. It's a very difficult state to practice law in many ways, particularly criminal law. You'll notice North Carolina is high up in the pack, but nowhere near as high as, say, Florida, Virginia, Ohio. California is our most populous state. It has 13. All right, so there has been a decline since 2002, 2005, what are called the Atkins and the Roper cases. You can't execute people that are mentally ill, that are mentally handicapped, and you can't execute juveniles. Also, although the majority of the Americans in 2013, we had a poll favored the death penalty, about 60%. If you say there's an option of life without parole, that falls to 48%. There has been a bit of a decline, depending on how the question is asked, in the death penalty's support. But the Supreme Court of the United States has grown steadily more conservative. It has shown no interest whatsoever in striking it down as unconstitutional. So if the death penalty ends or survives, it's not going to be the Supreme Court of the United States that is going to be the different states and the public. All right, well, that concludes the lecture. I wanted to keep it right around 35 or 40 minutes. So I'll be moving on to lecture 10 coming up, but I hope everybody's doing well, and I will talk to you all later.